How do I protect my invention? That's probably one of the most common questions I get when I talk to researchers. In today's talk, we're going to talk about intellectual property and what you should think about in protecting your invention. My name is Patrik Blomquist. I'm a business coach at K Innovations. Today's lecture, the goal is to inform you about different kinds of intellectual property rights protection, talk a little bit more about patents and also other things that are important for you to consider. So why should you protect your idea? You have this fantastic product or service and you want the whole world to use it. Well, first of all, there might be reasons for you to protect it in order to control your intellectual property, so the people that use it in the way you intend them to use it. And then, of course, there might be financial reasons to protect your IP. For example, you might have investors that want their money back. Then they have to have an exclusivity when you get on the market. This table lists a number of different types of IP, what they're good for and their limitations. I will now go through them one by one. Patents. Patents are used to protect new inventions. One example are chemical molecules, in this case the aspirin molecule. You get the patent by applying and then it's examined by authorities. The lifetime of patents are 20 to 25 years and it's a national right. I will talk more about patents later on in the talk. Copyright protects original creative and artistic forms. For example, it's a picture, a poem, a piece of music. It's created automatically, and the lifetime is 70 years after the creator's death. And it's an international right. Trademark. Trademark is the distinctive features of a product or a service. So for example, our logotype is a trademark. You get a trademark either using it or registered your trademark. It's valid for 10 years at a time as long as you use it. Trademark is a national right. Registered design. It actually protects the external appearance of something. One example is the Coca-Cola bottle. You get it by registered design and it's valid for 5 years at a time up to 25 years. And it's a national right. Sometimes the function of something, like a syringe for example, could be built into the design. So this in some cases can be a very important way to protect your invention. Trade secrets. That's used for information you don't want to be publicly known. So you need to keep it secret from everyone else. You do that by having agreements with your co-workers and your collaborators, and you can do your best just to keep it secret. The lifetime is forever. It's an international protection, and one example is the pyramids. They've been there for thousands of years and we're not sure how they built it, and there's no documentation to reveal their secrets. So why is intellectual property rights important for you as a researcher at KI? Well, in Sweden at the universities we have something called the teacher's exemption or lärarundantaget. It's stated in the law that everything invented by researchers belongs to the researchers. And also at KI there is a policy that says that if you invent something, you own it. There are some exceptions. For example, KI retains the right to use your inventions in the teaching and in the research activities they perform. And also the biological and chemical materials belongs to the university. It can be transferred to a company, but you need an agreement to do that. However, there are some exceptions to the teacher's exemption. The most common one is people working in the clinic. So clinical staff are not employed by the university and thereby the law does not apply to them. However, there is a mechanism to secure you the ownership of your inventions if you work in the clinic, and we can help you with that. The other exception is industrial collaboration. So you might be involved in a collaboration with the company, and there is probably an agreement that regulates the intellectual property rights in that collaboration. Foreign universities. Since this is a Swedish law, if you have collaborators at the foreign university, it will not be the researcher that owns the invention, but rather the university. So then you have to deal with their tech transfer office and not with your co-workers. You might have signed some sort of agreement, like a consortia agreement for a research consortia. You need to keep track of those. And then you have undergraduate students. Since students are not employed, they own their own intellectual property rights. Which means if you have a master student in your group, you need to have an agreement with them in order to secure the IP. So, patents. Patents does not ensure that you can make money on your invention, because it's a negative right. So you can prevent others from making money on your invention. You could be dependent on other people's patents. That's called freedom to operate. And you need to find that out before you launch a product or a service. There might also be regulatory and legal aspects why you can't just launch a product. A typical example is pharmaceuticals. You need to go through the different regulatory steps in order to be able to launch a product in the end. Patents and also patent applications are transferable assets, which means that you can make business with a patent or a patent application. To be granted, patents have to fulfill 3 different criteria. It has to be novel, so you should not have published this before. It has to be inventive, so it should be different from what's already published. It has to solve a problem. That means that tomorrow you will be able to do something that you couldn't do today. So, if you decide to file for a patent, you have to think about the patent strategy. First of all, you need to decide what to protect. Secondly, the timing of that filing compared to publication, for example. Also about financing, so you have a finance plan in order to pay for your patent applications. And you should also consider other forms of protecting your invention in relation to patents. So what can you patent? Here again, the aspirin molecule. So what you could protect is actually the molecule itself, or the substance of matter. You could also protect the use of that molecule in a certain disease, for example. You can protect the formulation. So how do you formulate the end product before you give it to a person? You can protect the synthesis of the molecule. And you can also protect a device that actually administrates the molecule into the body. For example, if you want to reach the brain, you might have a specific device that does that. Patent timelines. Patenting is a legal process, and certain things are really critical. One thing is timing. So say that we file a patent at month 0. The cost of that is about 50 to 100,000 kronor, depending on how big the patent is, how much drafting the lawyer needs to do, and so on. After 6 months, you get a search report. In that search report, the patent authorities, they list the number of documents that they have found that might infringe on your patent. Within 12 months, you need to file a PCT application. The cost of that is around 70,000 Swedish kronor, and much of that cost is actually the official fees. After 18 months, your patent becomes publicly available, which means 2 things. First of all, your competitors, they will see your patent. Secondly, there might be someone else that patents something before you file your patent, but you don't see it when you file your patent. After 30 months, you need to decide which country do I need my protection in. And that is a very costly process, and the cost of that is at least 250,000 Swedish kronor. Then you have yearly costs in all the countries, and you also have costs associated with the granting of the patent. So, where do you turn to if you want to know more about patents? First of all, the national patent offices, they have a lot of good information. One example is the Swedish Patent och registreringsverket, PRV. They have a lot of information about different types of IP, design, trademark, patents, etc. And of course, you have the KI rules on intellectual property that you should look into, the policy around that one. And you also have patent lawyers are very willing to share their knowledge. Some of them even have good information on YouTube. Other things that are important for you to consider is things like secondary occupation or bisyssla. You have to report that to KI, and you also have to report it, of course, in your scientific publications. You have conflict of interest, or jäv in Swedish, that can sometimes arise when you do something that conflicts with your research. You should also remember that the researcher and the research-owned company are not the same thing. These are two different legal entities, and you might need an agreement to transfer the assets between those. And you should also think about to separate your commercial and your research activities in the lab. So different types of agreement that might be important for you. First of all, is non-disclosure agreement or confidential disclosure agreements, which means that you can share secret information between two parties. You should remember there's a difference between a one-way and a two-way agreement. So if you decide to start a company, you have to write the founders or shareholders agreement that states what you're going to do and what you're going to put into the company. You will probably also need the IP transfer agreement that transfer the IP that you worked on as a researcher into the company. So how can we support you? Well, K Innovation supports things like asset inventories, IP strategies, patentability. We can even pay for a patent application. We might help you with some legal support regarding collaboration with companies. Today's take-home message is: list your critical asset, seek professional advice, create a strategy, and keep track of all your agreements. If you want to know more, contact me or one of my colleagues at K Innovations. We're here to help you. Thank you for listening.